If you were arrested for domestic violence and you either didn't do anything wrong or maybe it wasn't your proudest moment, but you weren't violent, you didn't commit domestic violence, then this video is for you because I'm going to be answering a question that actually a client recently asked me. He said, when is the judge going to ask me my side of the story? And in this video, I'm going to be answering not just that question, but also going through the 5 different times that the defendant's story gets used in a criminal case, especially a domestic violence case. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you how to represent yourself at a restraining order hearing and win. A lot of times when you get arrested for domestic violence, if the alleged victim is not on your side, the next step is that they file a restraining order against you. You've just posted bail. Hopefully you've hired an attorney, and so hiring an attorney for your restraining order may not be an option, but you can represent yourself and win. You just have to know how to do it, which is what I teach you in the course. So if that is something you're interested in, get your free first class via the link down below. Okay, so let's jump right in. Let's answer that question and let's get into those 5 times when a defendant's story gets told in a domestic violence case. So when my client told me this, it wasn't as much of a question as it was an observation or almost like a tearful complaint. He's like, I go in front of the judge and the judge never has me say anything. He never asks me my side of the story. When is he going to do that? Okay, the answer is never. Not because he doesn't care about your side of the story, but because he knows I would jump up and down and go crazy if he did. In the United States, you have a 5th Amendment right not to incriminate yourself. So you may be thinking, yeah, but I'm not going to incriminate myself. You might accidentally. You may think that whatever you did wasn't a crime, maybe grabbing something from the other person, or maybe you pushed them after they slapped you, and you may think that's not a crime. But depending on the circumstances, it could be considered that. So we as defense attorneys who want our clients to get the best possible outcome, we don't want you just making a statement in front of the judge. That is not going to be helpful to you. First of all, during most phases of the case, with very rare exceptions, the judge cannot just dismiss the case. So even if you were to tell the judge your side of the story and the judge said, hey, this case should be dismissed, the judge literally cannot do it. All that is going to happen is that the prosecution is going to keep a record via the court reporter of whatever you said, and if possible, they will use it against you. So it will not help, and it can hurt. And so you have the right not to say anything, and that is part of why you have an attorney, whether it's a private attorney or whether it's a public defender. We speak for you. We get your story across to the other side. A big part of being a good attorney is being able to tell my client's story in a convincing way to the DA and really show that I care about my client and I believe their story. And the first time that the defendant's story gets told is going to be through an attorney before court. If you have an attorney, contact the prosecution before court and give your side of the story. Your story can be used to your benefit, but it can't be used against you. Many times before court, if you got arrested for domestic violence and you have no criminal record, we can explain your side of the story to the DA, plus give them character letters, a description of who you are as a person, and get them to give you a second chance, not file charges, drop the whole thing altogether, and avoid any risk of you having a criminal record. The second time that a defendant's story gets used is when your attorney is talking to the DA at court. So if charges get filed against you, a lot of what happens at court dates is that your attorney goes, talks to the DA, explains succinctly what happened, explains that you are a good person, that this kind of thing is never going to happen again, explains the impact that a criminal record would have on you, and makes their pitch there. There's a line of defense attorneys generally at court who are going up to the prosecution, each making a pitch. And during that pitch is when your attorney gets to tell your story, gets to show that maybe the alleged victim's statement doesn't line up. Before we do this, generally, I want to get not just the police report, which is a summary of what everybody said and often is not totally accurate, but I want to get body-worn video and see exactly what the alleged victim said. See if I can find any inconsistencies or things that don't really make sense with whatever evidence that we have or just with everyone's sense of reality, and include that in my pitch, because the DA on the case for domestic violence cases is probably not really in contact with the victim, doesn't really know, probably not paying a lot of attention to the case. So I have to point those things out to them. And if I have a compelling story from my client, plus I can point out those inconsistencies, plus I can point out that my client is a good person who deserves a second chance, then I actually have a chance of helping my client keep a clean record. Number 3, at a DA supervisor meeting. So let's say that when I go talk to the attorney assigned to the case in court, that attorney just will not give me what I want for whatever reason. Sometimes we go to court and it's a different DA every single time. So maybe they just don't know enough about the case, or then they say, hey, this is what the last DA wrote down, and we just can't get any traction. Sometimes that happens. It's very, very frustrating because they're prosecuting the client hard without actually paying attention to the case really whatsoever and putting any effort in. The solution in that case in most counties in California is to set up a DA supervisor meeting where I sit down with the supervisor assigned to that courthouse and I explain to them the good things about my client and my client's side of the story, what evidence doesn't line up, any evidence I have in my client's favor. And most of the time, the DA supervisor will give us a better offer. Not always, but most of the time we can get that. Number 4, at trial by testifying. So when criminal defendants, when my clients want to give their side of the story, a lot of what they're imagining and they're thinking of is sitting up there on the stand and giving their story to 12 jurors and to the prosecutor, to the judge, telling their side of the story. Now, that is not without risk, right? If you were up there on the stand as a defendant, everyone already thinks, well, you might be lying. Why? Because you have a massive incentive to lie. If you have, for example, like an eyewitness to a robbery or something who saw the robber running across the street and saw his face and is there to identify him, when you know that that's what the witness is there for, you're not thinking maybe they're lying, because what would their incentive be? But it is the exact opposite when you are a criminal defendant. And if you change your story in any way, even though you might have a good reason for doing so, maybe you did speak to the police, but you got cut off before you could explain something else, you're just going to look like a liar. So it can be very difficult to explain your side of the story. And of course, the prosecutor assigned to your case will do everything possible to make you look like a liar. So it can just make things worse. And for that reason, many times defense attorneys advise their clients not to testify. But sometimes, and I've done this before, especially in domestic violence trials where my client has no criminal history, I will have my client testify. I will prep him. I will try to poke holes in his story and be mean to him, asking him questions like a prosecutor would. And if I feel like my client is ready and can go on the stand, I will advise the client and let them know. Now, usually we'll see how strong the prosecution's case is first, but as opposed to gang cases, for example, really serious cases like that where your client does have a lot of criminal history, first-time domestic violence cases are cases where it may make sense, or at least not be totally crazy, to have your client go on the stand and testify. Number 5, at trial through your attorney. Now, whether or not you testify at trial in your own defense, if the case goes to trial, your attorney is going to have to, well, they don't have to, but I think good defense attorneys typically will tell a compelling story to the jury. Now, the burden is on the prosecution, right? The burden is on the prosecution to prove that you are guilty of what they're accusing you of beyond a reasonable doubt. Yes. However, as the defense, generally, not always, but generally, it's not really advisable to just sort of sit back and say, you know what, they didn't meet their burden. You can do that sometimes, but especially for a domestic violence case, it makes sense to tell a story. It can be a girlfriend who caught you cheating and wants to punish you because of that. It can be a story of self-defense where you were attacked and you were simply trying to stop the other person. Maybe you're stronger than the other person, but all you were trying to do was stop them from harming you, which you have a legal right to do. Now, your attorney, through their opening statement, through their closing argument, through the questions that they ask the witness during the trial, can help get your story across and show that your story is reasonable. And that's exactly what the jury is supposed to be looking for. Do we have any reasonable doubts? If we think that the defendant's story might make sense, might be reasonable, then we do have one. And so that's a not guilty verdict. I hope you found this video helpful. If you do have a criminal case in California that you need help with, feel free to book a consultation down below. You can also find my number there. And if you did find this video helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.